remain standing until the conclusion of the reading of the proclamation. Ladies and gentlemen, the proclamation. All persons having any business before this honourable court, please draw nigh, give your attendance, and you shall be heard. God save the Queen.
Admission of lawyers. Maria Elizabeth Basher.
May it please the court, I move that Maria Elizabeth Basher be admitted as a lawyer of this honourable court.
Let Maria Elizabeth Basher be admitted as a lawyer of this court.
Monique Alexandra Bishop.
May it please the court, I move that Monique Alexandra Bishop be admitted as a lawyer of this honourable court.
Let Monique Alexandra Bishop be admitted as a lawyer of this court.
Pauline Chalita.
May it please the court, I move that Pauline Chalita be admitted as a lawyer of this honourable court.
Let Pauline Chalita be admitted as a lawyer of this court.
Janet Dunlop.
May it please the court, I move that Janet Dunlop be admitted as a lawyer of this honourable court.
Let Janet Dunlop be admitted as lawyer of this court.
Lachlan James Falvey.
Falvey lawyer, Your Honours. May it please the court, I move that Lachlan James Falvey be admitted as a lawyer of this honourable court.
Let Lachlan James Falvey be admitted as a lawyer of this court.
Ben Sonny Hughes.
May it please the court, I move that Ben Sonny Hughes be admitted as a lawyer of this honourable court.
Let Ben Sonny Hughes be admitted as a lawyer of this court.
Guthrie Isaac.
May I please the court, I move that Guthrie Isaac be admitted as a lawyer of this honourable court.
Let Guthrie Isaac be admitted as a lawyer of this court.
Diana Lubenkov.
May it please the court, I move that Diana Lubenkov be admitted as a lawyer of this honourable court.
Let Diana Lubenkov be admitted as a lawyer of this court.
Maria Mercedes Mamblona Camajo.
May it please the court, I move that Maria Mercedes Mamblona Camajo be admitted as a lawyer of this honourable court.
Let Maria Mercedes Mamblona Camajo be admitted as a lawyer of this court.
Jade Marguerite Mariani.
May it please the court, I move that Jade Marguerite Mariani be admitted as a lawyer of this honourable court.
Let Jade Marguerite Mariani be admitted as a lawyer of this court.
Nicole Tracy Rose.
May it please the court, I move that Nicole Tracy Rose be admitted as a lawyer of this honourable court.
Let Nicole Tracy Rose be admitted as a lawyer of this court.
Thomas Ryan Forward.
May it please the court, I move that Thomas Ryan Fullwood be admitted as a lawyer of this honourable court.
Let Thomas Ryan Fullwood be admitted as a lawyer of this court.
Lydia Mary Watson Moore.
May it please the court, I move that Lydia Mary Watson Moore be admitted as a lawyer of this honourable court.
Let Lydia Mary Watson Moore be admitted as a lawyer of this court.
Madeline Williams.
May it please the court, I move that Madeline Williams be admitted as a lawyer of this honourable court.
Let Madeline Williams be admitted as a lawyer of this court.
Zainab Zain.
May it please the court, I move that Zainab Zain be admitted as a lawyer of this honourable court.
Let Zainab Zhang be admitted as a lawyer of this court. It will be necessary for the purpose of an oath or affirmation that all those being admitted today stand up but remain in their current places. Could all admittees please stand?
Maria Elizabeth Basher. Monique Alexandra Bishop. Pauline Chalita. Janet Dunlop. Lachlan James Falvey. Ben Sonny Hughes. Guthrie Isaac. Diana Lubenkov. Maria Mercedes Mamblona Camajo. Jade Marguerite Mariani. Nicole Tracy Rose. Thomas Ryan Forward. Lydia Mary Watson Moore. Madeline Williams. Zainab Zain. Do you severally swear or declare and affirm that you will truly and honestly conduct yourselves in the practice of a lawyer of the Supreme Court of New South Wales, and that you will faithfully serve as such in the administration of the laws and usages of this state according to the best of your knowledge, skill and ability? Do you please say so help me God or I do?
Please be seated. Now that the formal part of the proceedings has ended, I'd like to warmly welcome you to the Supreme Court of New South Wales. Present with me on the bench today to my right are Justice Ward, who is the Chief Judge of the Equity Division of the Court, and Justice Kuntz, who is a Judge of the Equity Division. To my left is Justice White, who is a member of the Court of Appeal. Together, we constitute the court that has, in exercise of its jurisdiction, admitted you to practice. As we gather here today, I would like to begin by acknowledging the traditional custodians of the land on which we meet, the Gadigal people of the Eora Nation, and pay my respect to their elders, past, present and emerging. We recognise the long-standing and enduring customs and traditions of Australia's First Nations and acknowledge with deep regret the role our legal system has had in perpetrating many injustices against Aboriginal and Torres Strait Islander people. To all the new lawyers here today, welcome to the legal profession. Today is a day for celebration. You have all worked extremely hard to get here through caffeine-fuelled nights and obscure problem questions, reading countless wafer-thin pages of textbook and more cases than you can hope to remember. Don't worry, it's quite easy. There's no problems if you forget most of them. You have entered the world of eggshell skulls, encountered the mysterious reasonable person, and have understood that the Constitution consists of so much more than the vibe of the thing. In becoming a lawyer, you have today joined a centuries-old profession with ancient origins. The custom of advocates swearing an admissions oath dates back to the 12th century. This court first admitted lawyers to practice in 1824, and by 1830, the names of lawyers were entered onto rolls in this state. You have now become part of this tradition almost 200 years later. Perhaps for some of you, or for your family and friends, that's how long it feels that you've been studying. On that note, I'm also pleased to welcome those with you today or watching on the live stream. For many of you, the support of your family and friends has been invaluable. No doubt, they have also been often on the receiving end of your finely polished skills of argument and persuasion. I hope you take the time to thank them today. The oath or affirmation you have made today is a serious one and deserves solemn regard. Whether you work in private practice, at the bar, in a community legal centre, or in an entirely different field, you should be known for your honesty, your integrity, and your commitment to justice. It is an acknowledgement of this weighty responsibility that we observe today's unique formalities, including the moving of lawyers, swearing of oaths, and even our somewhat unusual choice of fashion. On a lighter note, on one occasion some years ago, a young member of the audience asked if we were doing Santa photos after the ceremony. Regrettably, I had to let him down and tell him we weren't. However, although we mark this occasion with formality and tradition, not everything in the legal profession remains unchanging. You'll be unsurprised to hear that last year we had to adapt quite a bit. COVID-19 meant a rapid shift to increased use of virtual courtroom setups and technology to ensure access to justice continued in the midst of a pandemic. Things didn't always go smoothly, as those with me on the bench can probably attest to, and certainly inform me of the fact from time to time. There have been real difficulties to grapple with in terms of open justice, effective communication, and fairness to participants. And occasionally, a lawyer might even get stuck behind a Zoom kitten filter. But for all the challenges we faced, the impetus is greater than ever before us to prioritise flexibility and accessibility. Better use of technology and increased working from home arrangements have profound implications for how our legal system interacts with many people, including those in rural and remote areas, those with a disability, medical conditions, or carers' responsibilities. As the newest members of the profession, you are at the forefront of innovation in the law and have a unique opportunity to see through changes so that justice is done openly and equitably. There are, of course, other changes that deserve attention. When we think of the diversity of the legal profession, we encounter the duality that we have come very far and that much still needs to be done. Though women were not originally permitted to practice, since 2018, women have made up more than half of all solicitors with a practising certificate in New South Wales and currently make up 63% of solicitors under the age of 30. Women occupy many of the most senior positions in the law, including, of course, the Chief Justice of Australia. However, women continue to face challenges of representation, including amongst judges of this court and amongst barristers, particularly in speaking roles before the High Court of Australia. It is heartening to see that the local court of New South Wales has almost achieved gender parity amongst magistrates, but we must not be complacent about these issues. There are other noticeable diversity concerns that we must face head on. Aboriginal and Torres Strait Islander people and people from diverse cultural backgrounds continue to be alarmingly unrepresented in the legal profession, particularly within the judiciary and the ranks of senior counsel. We must also be alert to barriers to the profession for people from less privileged backgrounds. Law should not be a profession for the wealthy, and the idea that students may be dissuaded from studying law by the cost of a law degree, which this year has again increased, or because of other systemic issues, is troubling. Not just this, but we'll only achieve a truly diverse profession when barriers to advancement are broken down and people from different backgrounds are properly supported in a collegiate and inclusive environment free from harassment and discrimination. These issues are fundamental to a just and transparent legal system and to the legitimacy of the rule of law. We need diverse representation amongst advocates and judges so that all people who become involved in our justice system can be properly heard and fairly engaged with by a system reflective of our broader community. Despite these challenges, there is real scope for change. There is far greater diversity of background amongst junior lawyers than those who have been around for as long as me. And you only need to look around this courtroom and then at the paintings on the wall to see that this is so. You are in a unique position as new lawyers who are entering the profession at a time when more than ever your words and actions are having an impact for good. You are being heard and taken seriously when you agitate to correct injustices, whether it be speaking out about unsustainable working cultures, sexual harassment or bullying within the profession, unfair laws, or systemic failings affecting our society's most vulnerable. I urge you to continue to speak up for the things that matter. You are the future of the profession and will steer the direction it will take. As a lawyer, you will also need to make difficult ethical decisions at times. With regard to our personal characteristics, lawyers have been the butt of jokes for centuries. Cynics would say they are, of course, only a handful of lawyer jokes. The rest are true stories. Jokes aside, you must use the tools you have developed to think critically and not compromise on your fundamental duties to the court and the administration of justice and other ethical duties you must uphold. Now that you're lawyers, you can get paid to argue instead of just arguing for free. Of course, there is a lot more to it than that. You're an advisor, a problem solver, a mediator, and an advocate for the marginalised. As you go about your day-to-day work, remember that you are not merely dealing with the law in a vacuum, but law as it applies to people's lives. For this reason, you must try to deliver legal services competently and fearlessly, with courtesy and integrity. Justice Gageler, before he became a High Court judge, once said, "You must be prepared to give the same answer to the same questions for the same reasons, no matter who asks the question or for what purpose and in what context the asking may occur." That is foundational to upholding the rule of law. For those of you who will practice law, the way you communicate information to others will have profound consequences for access to justice. For a non-lawyer, the law, unfortunately, is often incomprehensible. One of your roles as a lawyer will be to make law accessible to others, sometimes by deciphering legal complexities, other times by deciphering poor legal drafting, and sometimes both. One thing you will regrettably strike throughout your career is legislation which seems carefully crafted with the objective of ensuring that no one can understand it. Your task is not just to understand it, but to explain it clearly to those whose rights and interests are affected by it. As lawyers, we must not keep the law locked up as something knowable only to us. A client seeking or reading your advice should be empowered to understand your meaning, not mystified and confused. So be clear and concise in your writing and your speaking. Plain English is powerful. Consider, do I really need to say aforementioned or herewith? Must I sprinkle in that Latin phrase? Should I really use double negatives, tautology, and wordy clauses that take up a whole page? Are split infinitives generally desirable? I would suggest the answer to those questions is a resounding no. The best advocates can make their points simply and succinctly. Some of the most experienced lawyers and judges could also use that reminder. Do not pick up bad habits from looking at how judgments are reported in the law reports. I also want to speak about failure. I would not be surprised if there are quite a few overachievers and perfectionists in the room today. Even so, at various points of your career, you will make mistakes, some minor, some more serious. When you do make mistakes, your commitment to honesty, integrity, and the administration of justice means that you must take responsibility, correct what you can, and learn from those errors. You must fail at times in order to grow. I myself have made many mistakes over the year, too many to remember. What is important is that you try not to make the same mistake twice. Even as Chief Justice, my decisions have on occasion been successfully appealed to the High Court. At those times, I'm forced to remind myself that the High Court is never wrong. But in fact, even dissenting High Court judgments or overturned Court of Appeal judgments later become the law. Finally, I want to emphasise that your mental health is extremely important. This may sound unexpected at this type of ceremony, but the law is not everything. There may be times when you feel overwhelmed, burnt out, or distressed. If you do, you should not be afraid to seek professional help or to take a step back when you need to. Always remember that the law is a collegiate profession, and in times of difficulty, the support of your peers will prove invaluable. Although you might find it hard to believe, I was admitted quite a long time ago. I lost my first case, and I lost many more after that, probably more than I won. But throughout my 35 years in practice, I could always count upon the support of other barristers in my chambers who shared my disappointment at the unfairness of the verdict, the sly tactics of opposing counsel, and most often, I regret to say, the obtuseness of the judge or judges before whom I was appearing. I hasten to add that I do not include any of my fellow judges on the bench in that comment. On behalf of all the judges of the Supreme Court, and particularly those sitting today, I once again congratulate you on your admission and welcome you to the legal profession. The court will now adjourn.
All stand. This honourable court is now adjourned. God save the Queen.